And welcome to today's webinar, which is specifically for the health and care service sector. And today we're going to be talking about navigating the immigration rule changes that are coming in and impacting the international workforce in this area. So just to introduce myself, so my name's Sacha and I head up the immigration team here at Birketts, based in the London office. And also joining me today is Sara, who is a senior associate solicitor in the team and specialising in the care sector. So thank you very much for joining us. This is the first of our webinars in this series. There's going to be one later in the year. There's lots of government changes in this area with a specific target on the health and care sector. So it's an awful lot to manage. And we know as an industry, we're incredibly reliant on the fantastic international workforce that we have to look after our patients and provide amazing services. So this is really important that we're abreast of all the changes and ready to manage any Home Office inquiries and ensure our compliance. So lots of work for HR. I'm going to pass over now to Sara, who's going to give us an overview.
Thank you. So we thought it would be useful to put together an overview of what the health and care worker visa actually is for those of you who may not be too familiar. So ultimately, it's a subcategory of the skilled worker visa, which most of you will be familiar with. It was designed specifically for healthcare professionals and workers from around the world to come to the UK to work within the UK's health and social care sector. It was specifically designed in order to help address the skills shortage within the UK health sector by offering a route for foreign nationals to come to the UK for work with the potential of settling in the UK permanently if they wish to do so. It's an attractive route in that it offers fast-track entry to the UK. There are reduced visa fees compared to other visa routes. There's also an exemption from paying the immigration health surcharge, which in itself is a massive saving, as that fee is currently £1,035 per year of visa length. It also has a dedicated UK VI application processing team, which helps to ensure that applications are processed as quickly as possible. The route is also attractive in that it offers lower salary requirements compared to the standard skilled worker visa, and it also allows individuals to bring dependents with them to the UK, such as a partner and/or children in certain circumstances. There are a full list of eligible roles and occupations that are eligible for the health and care worker visa, and these can be found on the UK VI website in full. Now, in terms of the current costs for the health and care route, we thought it would be helpful to put together a table just to show you what the current cost structure looks like. Ultimately, the cost of the visa is driven by the duration of sponsorship. We typically notice that employers tend to sponsor in usually 3 or 5 year increments. However, ultimately, this is a commercial decision. In the table that we've put together the cost for both a 3-year visa and a 5-year visa for someone applying by themselves without any dependents, applying in the UK, working for a medium to large size business. For a 3-year visa, you would be looking at £4,329 at present, and for a 5-year visa, you'd be looking at £6,615 at present. As I mentioned, this is for someone applying without any dependents and for someone applying from within the UK. As you can see on the table, there is no immigration health surcharge payable, as that is an exempt fee. And also, as you'll be able to see, that we've stated the priority service as being optional, as you do not have to pay this if you do not want to. The first 2 fees that we have highlighted on the first 2 rows are for the certificate of sponsorship fee and the immigration skills charge fee. The reason that we've highlighted those 2 fees is because under no circumstance can you claw back or pass those fees on to your employee. We'll be talking about that a bit more in the next slide. In terms of managing costs, as I just mentioned in the slide before, the certificate of sponsorship and immigration skills charge fee are not recoverable under any circumstance whatsoever. If the Home Office found out that you were asking the employee to pay you back for that fee, you could end up losing your sponsor license potentially. So even if you have a circumstance where you've offered someone sponsorship, they start working from you, and a month later they resign because they found a better job elsewhere, you cannot then ask the individual to pay you back the certificate-related fees. Those fees are not recoverable at all. Similarly, recruitment fees are not recoverable as well. So if you use an agency to identify the worker to work for you, you cannot ask the employee to pay you back any agency-related costs. If you wish to do so, you can have a clawback arrangement. Typically, we see this as an addendum to an employment contract, and they typically are on a depreciating basis. If you wish to have a clawback arrangement in place, we'd be very happy to check this through with you and to consult with our dedicated employment team to ensure that you have drafted this correctly and that you are clawing back the relevant costs that you are permitted to claw back. If you wish to offer a loan to your employee to help with paying the visa-related fees that you may wish for them to pay themselves, that is absolutely fee. However, please remember that there are benefit in kind tax rules with the typical cap at £10,000 per year. You may also have different policies in place depending upon the seniority of the individual working for you. You may have a level of cost support saying that if they're more senior, you will pay all of the relevant fees for them, or you may have a policy in place saying that more junior people must pay all of the relevant visa application fees themselves, apart from the certificate fee and immigration skills charge fee. You may also wish to have a policy in place regarding dependent family members, whether that's that the individual has to support those applications themselves, or that you will support the applications for the dependent family members, potentially depending upon their seniority. You may also have a policy in place regarding elements that you will and will not be covering, such as asking the individual to pay the application fee themselves and only providing them with the certificate of sponsorship once that has been assigned. That's absolutely fine to do. And if you do have any queries in respect of any policies that you have drawn up, we would be very happy to check these through with you. Now, moving on to upcoming visa changes, which is the current hot topic all over the news at the moment, we thought it would be helpful to put a few slides together pertaining to this. I thought it would be helpful to summarize the changes prior to the May 2025 white paper that has just been released. So following the statement of changes that was published in March earlier this year, a few changes came into effect from the 9th of April. The first one being that the minimum hourly rate required to be eligible for visa sponsorship increased notably from £11.90 per hour to £12.82 per hour. The minimum annual salary required to be eligible for visa sponsorship also increased from £23,200 per annum to £25,000 per annum. For unbanded roles, this remained at £29,000 per annum. Additionally, on the 12th of March, the following change also came into effect on the 9th of April. There was an imposition of a sector-specific resident labour market test for care workers and senior care workers within England, with providers being required to demonstrate that they considered a pool of displaced workers before hiring from overseas. And there was also a change in approach so that any deductions from employee wages for immigration costs will be included when calculating if minimum salary requirements would be met. So quite a few changes did come into effect on the 9th of April. Then just a month later, on the 12th of May, a white paper was published with the intention of reducing net migration significantly. We put together a few bullet points with specific proposals with impact to the care sector, some which we've now had a bit more clarity on since the 12th of May. The first one of notable consideration is the closure of the care worker visa route to new applicants from outside of the UK from the 22nd of July onwards. This ultimately covers occupation codes 6135 and 6136, which are care workers and senior care workers. These are occupation codes which were added to the eligible list of roles under the skilled worker route in February 2022 as a temporary response to labour shortages in the social care sector. There is going to be a grace period, so those who are already in the UK on a care worker visa or switching from another route will be allowed to extend or switch their visas until 22nd of July 2028, and transitional provisions will apply to anyone applying before that date. In respect to further leave to remain applications, if anyone wishes to work in the UK under both of those SOT codes, there's a requirement that the workers must have been legally working for the provider that is sponsoring them for at least 3 months before the date of their certificate of sponsorship being issued to them. So what that means ultimately is they would have to demonstrate that they were already working for you, whether that's as a dependent or on a student visa or on a graduate visa. If they're unable to demonstrate that, they wouldn't be able to switch onto a certificate of sponsorship under either of those SOT codes. A few more proposals that were published on the 12th of May that we don't have any further clarity on at present. One being the time to count towards settlement being extended from 5 to 10 years. At the moment, someone that wishes to settle in the UK has to accumulate 5 years worth of time in the UK on an eligible visa route. What the proposal was saying is that they want to increase that time to 10 years. We don't know at present whether that is going to be implemented. We don't know at present whether that's going to affect everyone in the UK already on a visa, or whether that will only affect people from a certain date going forward. We also have been told that the English language requirement will soon be applying to dependents as well. At the moment, dependents only need to satisfy an English language requirement in respect of settlement applications or naturalization applications. If that proposals go ahead, then dependents will need to satisfy the English language requirement for any entry clearance and further leave to remain applications as well. At the moment, we don't know if that is going to come into effect or when for definite. An additional proposal is an increase in the immigration skills charge cost, which will be increasing by 32%. The fee for small and charitable sponsors will be rising from £364 to £480.48 per year, whereas medium and large sponsors will see an increase from £1,000 per year to £1,320 per year. So quite a steep jump. At the moment, we don't know when that change will be implemented. And finally, there will be an increase to visa application fees. This happens almost every year. We're unsure at the moment how much this will be increasing by, but all we can suggest is that you start planning ahead now and don't leave applications too late. On the 1st of July, there were some further changes that were confirmed that will be coming into effect from the 22nd of July. There will be the removal again of the sector-specific resident labour market test for care workers and senior care workers within England, meaning that providers no longer need to consider a displaced pool of workers before making a job offer. Ultimately, this is because there will be no further entry clearance applications permitted from the 22nd of July. The general salary threshold will be increasing as well from £29,000 per year to £31,300 per year for unbanded roles for those who were in the route before April 2024. For SOC code 6135 and 6136 for care workers and senior care workers, they will luckily remain at the £25,000 threshold without any change. For any individuals who became a health and care worker visa holder after April 2024, the general threshold will increase from 38,700 to 41,700 for unbanded roles. SOC code 6135 and 6136 will still also remain at the £25,000 threshold. There will also be an immigration salary list which will be phased out from December 2026, and the following roles will now appear on it and must be paid a salary of £25,000 per annum, or their occupation growing rate, whichever is higher. So that will be SOC code 1232, 3111, 3212, and 6131. And now I'll pass over to Sacha.
Thank you very much. So we thought, that's a lot of changes, and appreciate there's a lot to absorb there. And as Sara's intimated, there's going to be more changes as well. So really, the message here is that this is a really good time to take stock, to understand how these proposals might impact your workforce. And you want to be looking at that for both an operational perspective. Can you continue to deliver the service as you are already, and have you got room to adapt to changes in service demand? But also from a budget perspective, it's obviously going to cost an awful lot more going forward. It's already very expensive. So do you need to manage your budget and make changes by looking at your policies, as Sara mentioned earlier? So reviewing your internal policies can be really key. And obviously the whole point of these changes from the government is they're really encouraging us to retain talent as far as possible. So we do know that there is a fairly high turnover of staff within the sector, and losing out to other competing sectors in terms of wage and working conditions. So this is a very intentional move from the government to improve working hours, working practices, working conditions, to ensure that talent want to stay in the industry. So what can you do internally to look at how you're operating and other things that you can change to make it more attractive for staff to stay with you? There is also a short window to get ahead of the rule changes. So before the 22nd of July, if a certificate of sponsorship has been assigned, you can still file the visa application after the 22nd of July. So there is a small window if it's possible to assign certificates before then, but thereafter, as further changes come down the track, we're expecting similar rollout of rule changes. So there'll be an announcement with dates for implementation. So by being aware of the changes as they're coming down the track, you can position yourselves and say if it's necessary or helpful to make early visa applications. We see this most commonly, for example, where you've got people in the business on graduate visas. They're going to need sponsorship to stay. So making sure you've reviewed your workforce, you've identified that demographic of staff, and you understand if you're able to switch them over, will they meet the salary requirements, and is it beneficial to apply earlier to save cost or to ensure they're going to be eligible to switch. So that can really help, and as I say, especially the immigration skills charge as that increases. But more generally, obviously, you're going to need to look at your budget, forecasting salaries, recruitment costs, etc. I mean, for some, maybe it will be beneficial to your recruitment budgets if you're not recruiting from overseas because that's no longer viable. But we know it's difficult to get the workers, so it's going to get very competitive, and those funds that might therefore need reallocating elsewhere. It might be beneficial, and most commonly we see with employers, typically our workers are sponsored in 3-year increments. Again, to kind of get ahead of rule changes, you can sponsor 5 years at a time. So although it's more money up front, you might find it beneficial in terms of retention of staff and kind of getting ahead of rule changes if you sponsor for 5 years at the outset. So that's really helpful. And again, as I've said, reviewing salaries for kind of all your workers to see if they're going to meet requirements for sponsorship, if that's likely to be necessary. And also a key thing, which I'm going to talk about in just a moment, is ensuring your HR systems and processes and operating model is really robust. We're seeing a lot more audit and compliance activity from the Home Office and any organisations in the health and care sector that sponsor international workers or have international workers, so not exclusive to sponsors, but anyone with international talent. So taking time to review that now and getting ahead of the Home Office coming in is really helpful and important to do. It's not just to stay on the long list. I know it's difficult to get round to with competing demands on your time. So talking about that, so then audits, as I say, I mean, I've kind of been blown away really since the government's changed, and it's not really surprising given the political landscape that we're operating in, but we've seen a really huge gear shift from the Home Office in terms of their compliance and enforcement activity. So last year alone, the Home Office suspended over 1,700 sponsor licenses, and of those 1,700, they chose to revoke 1,500. So really vast and drastic action from the Home Office. And just in the last 2 years, specific to the care sector, 470 sponsor licenses have been revoked. So you can see there, the care sector has accounted for about a third of the sponsor license compliance action that's been taken by the Home Office. A lot of that has come around, and you will have seen it reported in the press. Some rogue operators that are really not doing justice to the good work of the rest of the sector, but rogue recruiters, rogue organisations that have brought people into the UK, then don't have the requisite work for those employees and have left them sort of high and dry, or have had very bad compliance. And we've had instances of modern day slavery and debt bondage. So as you might expect under a Labour government, there's a lot of focus on stamping out that bad practices from those few rogue employers that they give the industry a bad name. But that does unfortunately mean everybody's getting targeted, and the Home Office are really clamping down. So as I say, unfortunately, it's not just a nice to have on the long list, but really actually imperative that you are in a really strong position, because anyone in the health and care sector, I would really advise that Home Office audits are pretty imminent. We've had many organisations that have had licences for years and haven't been reviewed, but it's something the Home Office is taking very seriously now. So Audits and compliance checks are undertaken in a variety of manners. So either, and this is usually if the Home Office think there's a real severe problem, they may turn up unannounced in person. So uniformed officers will just one day arrive at a care site with a view to undertaking an immigration inspection. They're not as common, but as I say, in the most grave areas of concern, that can happen. Most commonly, it's by pre-arranged visit. You wouldn't get an awful lot of notice, maybe a week at most. And the reason for that is they give enough notice to make sure somebody's going to be available to speak to them, but not so much notice that there's time to do lots of remediation and improvement on your files. It's a bit like Ofsted inspecting a school. They want to see how you genuinely are operating day to day. So they won't give you too much notice because they want to see how you do genuinely operate. But increasingly, actually, what we are seeing is that rather than whole-scale in-person audits and teams of Home Office officials arriving on the premises, a lot of the audits are being undertaken on a desktop basis. So requests for information, copies of data and files to be sent via email to the Home Office, and interviews being undertaken with the relevant compliance officers in a company via Zoom. So the ability of the Home Office to do audits remotely is also increasing their capacity to do more audits and enforcement checks, which is why, as I say, it's not something you can assume will pass you by, because the Home Office have got a lot more resource to be able to do lots of checks on more sponsors. So typical triggers for compliance action. I mean, if you do hold a premium sponsor status, then it's mandatory that you're checked annually anyway. But I say where there's particular concerns around a sector, as we've seen the Home Office have for the care sector, we have similar concerns from the Home Office in respect to construction and also hospitality, as you might have seen reported, but the care sector absolutely is an area of focus. And we're also seeing lots more cross-government department data sharing. So one of the key triggers for an immigration audit will be data that they get from HMRC. So we've seen over the years examples of student visa holders working in breach of their visas by working too many hours compared to what they are permitted on their visa. The way that was identified is by the fact they were paying too much tax. So you might think it's a good thing that they were paying into the system, but the Home Office used that data to assess that people were working in breach of their immigration conditions. It's also not unusual if you've got an aggrieved employee or family members, if there's been sort of family disputes, where reports are then made to the Home Office to say, I think something's going wrong in that business and it needs looking at. And so ultimately that's leading to rates of refusal. But other areas where we see triggers for Home Office audits is if you have challenges with your operating license or registration status. So if you're CQC registered and you're found to be in need of improvement, that is likely to also trigger a Home Office audit. So when it rains, it pours sometimes, and I think that's how it would feel. But definitely anyone that's failing or struggling in CQC inspections would be a focus of Home Office attention. And then we just see general ad hoc points of check and inquiry, so routine inquiries to check your compliance. So when you're assigning certificates of sponsorship or filing visa applications for employees, those are common points where the Home Office say, oh, while we're looking at this, can you just send over some example files so we can see what your right to work procedure looks like? Can you explain to us how you identified this candidate? What recruitment agents do you use, etc.? So those are fairly routine rather than sort of information led, but lots of different reasons that are triggering audits there. And if they do come to take an audit, I want to be really clear that they're not only going to be looking at the files that you've got for your sponsored workers. Obviously, that's a large part of the process, but fundamentally, and where we're seeing the biggest instances of revocations is actually just general poor practice with right to work procedures. So they will ask you to see right to work checks for your British nationals, Irish nationals, EU workers that have been in here for years and they will have a Brexit status, your non-sponsored workers and your sponsored workers. So that is all encompassing when there's a Home Office inspection. So they want to see that you're doing right to work checks, and they want to see that you're doing really robust tracking of visa expiry dates to make sure you don't have illegal workers in the business. And also, as you'll be aware, where you sponsor workers, you're obliged to report to the Home Office in terms of change of job, pay, work location. So anytime there's a change in their working conditions, you have to report that to the Home Office. One of the areas I think I probably see the most non-compliance with the care sector is, but obviously there's lots of mergers and acquisition activity, lots of takeovers by groups of maybe smaller independently owned healthcare services and care homes. If they are not reported correctly to the Home Office in a timely manner, so normally you've got just 20 days after a transaction completes to report to the Home Office that there's been a change in owner. So even if the business hasn't changed, the day-to-day operations are the same, you do have to report those changes in ownership to the Home Office. And again, the Home Office are taking data from Companies House and saying, oh, you've made a filing on Companies House, but you don't appear to have told us in the Home Office. And unfortunately, there's not a single reporting service. You have to report separately. So that's a really common area where we're seeing, especially in the care sector, issues with compliance, and that would lead to revocation for failing to comply with that. And then beyond that, kind of more day-to-day requirements. So maintaining records of migrant contact details. So ultimately, as a sponsor, you are the gatekeeper for the Home Office. Do you know where that worker lives? Are they turning up to work as expected? Are they operating in line with any absence policies that you may have, holiday policies? Is any period of leave from work, whether it's parental leave or sick leave, is all that being reported as and when required with the Home Office? So monitoring their absences, and ultimately just retention of data and files. So probably the most common thing I'm seeing at the moment is lots of employers will have right to work checks, but they can't provide any evidence to ensure that they check that the international worker entered the UK after the visa had been issued. So the sponsor guidance says, oh, you should have checked their boarding pass or their landing stamp and the passport to check that they only came into the UK after the visa was issued. I don't think any client that I've worked with has had all of that for all their employees that have come in that have been sponsored. So it's a really easy one to fall down on. It's, buried in the depths of all the sponsor guidance, which is in lots of different places. But it's therefore really easy for the Home Office to identify non-compliance. And what we're seeing is, historically, they might have been a bit more pragmatic and give you a slap on the wrist and allow you to carry on. And what we're seeing now is the Home Office far more incentivized to remove licenses than they have done historically, which is leading to those high revocation numbers. So then just briefly, in terms of how that Home Office kind of undertake the review, I've obviously mentioned that they'll check all demographics of staff members, so not just your sponsored ones, but they'll look at your sponsor license, assess that the summary page is up to date, and if you've made the relevant report. So if you've grown in size and you've got lots more employees, have you updated the Home Office? They'll want to check your individual personnel files and expect different records in relation to each demographic. So sponsored workers, there's lots more things that you have to retain on file compared to British nationals, for example. And they'll want to see what your HR systems and procedures are. So if you've got a manual or policies and processes that are written down and protocols, they'll want to review those. And then the common one, which people are not always prepared for, is that the Home Office will undertake interviews, not only with HR and the people in charge of compliance, but also with the workers themselves. And they will cross-check that the answers given by the workers match the information held on file. And again, there's sometimes those things don't match up terribly well, which can lead to issues. And I say, and probably the most concerning for anyone on this call is, say, the authorising officer, the person in HR typically, or the board member or director of a company in charge of recruitment, will be interviewed by the Home Office and expected to explain all the requirements that you have as a sponsor and how you practically undertake that day to day. So there's quite a lot involved in it. And as I say, sadly, it's all too easy for the Home Office to find things that they're not happy with because there's an awful lot of guidance to get through. So not to scare you too much, but I think it's better to be forewarned and to be therefore forearmed. And it's better to take the time now, as I say, to prepare yourselves in case anything does arise. So kind of a few things and key takeaways really from us is don't leave it too late. Plan ahead. The Home Office do typically, anytime there's going to be rule changes, they'll normally give at least 21 days notice before the rule changes are implemented. So we know the direction of travel. The white paper was just a policy proposal of the direction of travel. There's then some consultation, and then the rules are being announced in tranches. So make sure you get ahead of that. As I say, recruiting staff before the rules change, and being prepared and looking at your what your strategies are going to be for coping once you can't hire new workers from overseas. Looking at early sponsorship, as I mentioned earlier, and then making sure you're ready for audit and checking your compliance. And of course, we're here, any and all of the above of those things you might want help with, or you just want a bit of a sense check with us. Sarah, myself, the team, we're all on standby and happy to support you. And we've got lots of experience in the care sector, lots of clients where we can give you live examples of how things have been carried out with the Home Office in the past. So really happy to support you with that in any way. And then as I say, stay in touch. So we do have a monthly update where we provide each month an update of all the employment and immigration rule changes that we think are really relevant to you. And we've got the healthcare sector newsletter as well. So if you go to the Birketts page online, you can make sure you're signed up to our newsletters. But importantly, Sara and I are here to keep you very specifically updated. So we're going to be doing a part 2 in this webinar series later as more changes and rules are being announced. And we're expecting those to be in the autumn. So we'll have these July changes. There'll then probably be a little bit of respite over the summer. And we'll expect a whole load of new changes again, most likely in October. So September, October is going to be a busy old time. So we'll come back and make sure you're signed up and come along to part 2, where we'll be talking through you that at that time. So thank you very much for joining. We hope you found that helpful, and see you at the next one.
Thank you.